Who decides what is appropriate for public libraries? That is the heart of the case Fayetteville Public Library et al. Versus Crawford County, Arkansas et al. The representatives of the people of Arkansas passed a law, Arkansas Act 372, which both established a crime for furnishing a harmful item to a minor and established guidelines for selection, relocation, and retention of such material. A group of libraries, librarians, and related organizations sued Arkansas's 28 prosecuting attorneys in the federal district court for the Western District of Arkansas. The district court issued a preliminary injunction preventing the law from going into effect. Or does it? We'll discuss that next on the Constitution Study.
Lovely neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach our and generation be free. I hope you enjoyed today's episode because there's a twist at the end. You may have picked that up when I let in at the beginning. There's a twist to this particular case. I'll get into it as we go through the rest of it. I'll also get into the website and other ways you can get engaged and get involved here with the Constitution Study. I'll do that at the end of the episode. For now, let's take a look at this case involving this Arkansas law. In March of 2023, the Arkansas legislature passed and Governor Sarah Huckabee Sanders signed Arkansas Act 372. The stated purpose of this was to amend the law concerning libraries and obscene materials, to create the offense of furnishing a harmful item to a minor, and to amend the law concerning obscene material loaned by a library. On June 2nd of 2023, a group of public libraries, library organizations, professional libraries, and others sued, claiming that Sections 1 and 5 of the law were unconstitutional. Specifically, Sections 1 and 5 of the Act remain vaguely worded and susceptible to multiple meanings. Section 1 violates the due process rights of professional librarians and booksellers and the First Amendment rights of library and bookstore patrons, and Section 5 empowers local elected officials to censor library books they feel are not appropriate for citizens to read, and allows, if not encourages, content and viewpoint-based restrictions on protected speech without any compelling governmental purpose. The libraries moved for a permanent injunction, preventing the law from being enforced, which the court granted. However, that injunction, and in fact the entire case, is legally moot. As I've quoted above, the plaintiffs claim that the law violates their due process rights. However, after reviewing their complaint, I find this claim questionable at best. First of all, while the complaint includes 3 counts where plaintiffs claim the law violates the due process clause of the 14th Amendment, there's a lot more to that story. Let's start by looking at that clause. Nor shall any state deprive any person of life, liberty, or property without due process of law. So where in this law is anyone deprived of life, liberty, or property without due process of law? According to the plaintiffs, the availability provision contains language purported to describe criminalized acts which is vague and indefinite and subject to different meanings, such that it fails to provide adequate notice to booksellers and librarians of violations of the availability provision, including the meaning of presents, provides, and makes available in Arkansas Code annotated 527-212b1. Are the terms presents, provides, and makes available vague? Well, according to Merriam-Webster's online dictionary, present is to make a gift to give or bestow formally, to bring something such as a play before the public. It also means to bring or introduce into presence of someone especially of superior rank or status, or to introduce socially, to offer to view, to bring to one's attention. Provide is to supply or make available, something wanted or needed. Also, to make something available to. And available means present or ready for immediate use. Now, none of the terms the plaintiff claims are vague actually are vague. Similarly, in count 6 of the complaint, the plaintiffs argue that the terms appropriateness and not accessible to a minor, as used in the law, do not provide any definite procedural safeguards or standards. Yet, Section 5 of the law specifically amends Arkansas Code for the establishment of guidelines for selection, removal, relocation, and retention of material. These guidelines include having written policies for the process of challenging material, addressing those challenges, standards for what can be relocated or withdrawn, and communicating decisions to parties involved. Other than these claims that the law does not provide any guidelines or standards, which is patently false, I do not see where the plaintiffs provide a single situation where they would be deprived of life, liberty, or property without due process of law. Their claims of due process seem to be based solely on a violation of the First Amendment. A person challenging material in the library has access to a written policy for the establishing of guidelines and how the library will address challenged material. The county librarian forms a committee of library personnel to review the challenge, and the person challenging the material is required to present his or her request to the committee. It seems to me that both sides have the opportunity to present their case, and I find it odd that the librarians who are suing to stop the law are the ones who vote to determine whether or not material should be relocated. Now, with the single exception of the question of procedural safeguards and standards, the 14th Amendment and its due process clause is always referred to with a violation of the First Amendment. However, this law cannot violate the First Amendment for one simple reason. It was not created by Congress. After all, the First Amendment reads, "Congress shall make no law abridging the freedom of speech or of the press." Since Congress did not make this law, it cannot violate the First Amendment. I can assume that the attorneys for the plaintiffs believe the lie promulgated by the Supreme Court that somehow the 14th Amendment rewrote the First Amendment, but it did not. Which brings up an interesting question. If the law cannot violate the First Amendment, did the district court have jurisdiction? From Article 3, Section 2, Clause 1 of the Constitution, we find, "The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority." So, although the plaintiffs claim a First Amendment violation, it patently is not. And since none of the plaintiffs articulated a reasonable claim under the 14th Amendment, the claim the district court made was wrong. The court found that at least one plaintiff has standing to challenge the constitutionality of Section 1 and 5 of Act 372, and that such challenges were ripe. If the district court does not have jurisdiction, then the injunction ordered by the court is invalid. And if the injunction is invalid, there's no reason why Governor Huckabee Sanders or the rest of the government of Arkansas should recognize and follow it. I know, it sounds radical, even anarchistic, but it is the law. The Supreme Court cannot rewrite the Constitution, so their claims that the 14th Amendment rewrites the First is unconstitutional, invalid, and void. Furthermore, the rationale the judge used involved violations of free speech, attempting to apply the First Amendment to state law, which is unconstitutional. First, it is overbroad because it regulates substantially more speech than the Constitution allows, and therefore violates the First Amendment rights of Arkansans. As I've shown, this cannot violate the First Amendment rights of Arkansans since Congress did not make this law. So this argument is invalid and void. Lastly, the vagueness argument is just plain foolish. Second, its terms are so vague that they fail to provide librarians and booksellers with adequate notice of what conduct is prohibited, thus violating their due process rights. But the terms are not vague, and the prohibited conduct is quite obvious. From Arkansas Act 372, we read, "A person commits furnishing a harmful item to a minor if, knowing the character of the item involved, the person knowingly furnishes, presents, provides, makes available, gives, lends, shows, advertises, or distributes to a minor an item that is harmful to minors, or transmits or sends to a person that he or she believes to be a minor by means of electronic mail, personal messaging, or other direct internet communications, an item that is harmful to minors when the person knows or believes at the time of the transmission that a minor in the state will receive the item." Prohibited conduct is stated plainly in the law. If librarians and booksellers know that something has been found to be harmful to minors and knowingly makes it available to minors, then and only then is it furnishing a harmful item to a minor. The court observes that in a factually similar case, Virginia v. American Booksellers Association, the Supreme Court held that booksellers in Virginia had standing to sue the Commonwealth to enjoin a law that would criminalize the commercial display of materials deemed harmful to juveniles. There is, however, a major difference between the Booksellers Association case and this one. The Bookseller Association represents private booksellers. This case focuses primarily on public libraries. As a public library, don't the politicians have the right to control? As public libraries, don't the people through their representatives have the authority to decide what is and isn't appropriate for those libraries? There is one area where I think this law can be improved. This law amends existing law to add loans at a library to this list of those liable for the possession, sale, or distribution of harmful material. Yet this law states that a person commits furnishing a harmful item if they knowingly do so. If it's supposed to apply to libraries, why doesn't the law specifically say so? Also, there's the question of knowingly. Say you work in a bookstore, library, or some other venue that provides material to minors. How is someone to know if a specific item has been found to be harmful to minors? Is it up to the owner to remove or segregate harmful material? Or if it's up to the salesperson, how are they to know? More disturbing is the fact that a district court judge either cannot read plain English or doesn't care about their oath of office. Which brings me to the next question. If the court got the question of standing so badly wrong, is the state of Arkansas required to abide by the order? Sure, Arkansas can appeal the judge's decision to the circuit court, and that might be the safer answer. But is it the most just answer? How many children will be exposed to harmful content because a judge cannot read or a group of unelected librarians think they have the right to distribute such content to them? Once again, we come to the question of who decides? Who decides what content is fit to be in public libraries? Representatives of the people or a group of librarians? To me, the answer seems kind of obvious, but that's just me. What about you? What do you think? Comment. Let me know what you think about this particular law. Sure, like most laws, this law could be improved, but the basic tenet, who is best to judge what should be in the public library? The public representatives of the people or a group of librarians? That's fundamentally the question. I'm not saying this should be deprived from everyone. Right? We're talking about harmful to minors. Do minors have access? And minors are minors. Now, I'm not saying parents should give up their authority to oversee what their children observe and to check out of a library or buy at a bookstore. But I remember when I was a kid, it was safe for my mother to leave my sister and I at the local public library to browse the shelves while she did other things. Yet when my daughter was young, I would not leave her alone in a library. It wasn't safe. Now, the idea of segregating material that is not safe for minors is a good compromise. In a library or a bookstore, let's have areas that are not for children, not for minors. And whether it be the librarian or the salesperson can restrict access to that area. But part of me wonders why so many people seem so dead set on taking material that most of us would consider harmful for minors and giving it to them. Do they think they're in charge of the children? They have a right to distribute material that is harmful to certain people? That overrides everything else? I don't know. I can't get in people's heads. What I do hope is that this will at least spark a conversation about the law, about the idea of what is harmful for children and how do we deal with it. We as parents need to take responsibility for our children. And we as a society should be looking out for what is best for our children, not for the adults. We should put our children first. At least that's my opinion. What's yours? Now, before I go, I want to remind you of a couple things. One is, I found this really neat course. It's called The Miracle of America. It's a history lesson, history course from the colonies through the drafting of the Constitution. It's really pretty cool. Find out more at constitutionstudy.com/1776 study guide. That's the numerals 1776 study guide. You can check out the details, but more importantly, you can enroll for a free lesson. I made a deal. You get a free lesson by going to that site as opposed to anywhere else. It's on God's natural law. It's absolutely free. and you can try out the class before you buy it. You get a downloadable study guide. You can have an hour of content, either video or audio, all of it absolutely free. I think you'll like it enough you want to take the rest of the course. The whole thing costs $17.76. Speaking of helping out, how about you check out Patriot Mobile? It's America's only Christian conservative wireless provider. They take their proceeds and they support organizations like the NRA, Folds of Honor, Turning Point, organizations that are working to protect our rights. Go to patriotmobile.com/constitution, find a plan that works for you. They've got the same level of coverage, 4G, 5G, across the nation. They use the same networks and the same towers. They just don't spend their proceeds on the same things. And if you need a little help, their customer support is top-notch and 100% US-based. By the way, if you use the code Constitution at checkout, they'll even activate your new line free. So again, go to patriotmobile.com/constitution, find a plan that works for you. Be sure to use that code Constitution at checkout to get free activation. I also hope you come back here and join us. Maybe share this information, share the links, bring a couple friends the next time we meet here for the Constitution Study.
Love your neighbors and have a few good friends.